Impacto de la propiedad industrial en el desarrollo de proyectos biotecnológicos. Juan Soria, director de SF500 Argentina. Gonzalo Rovira, Head of Intellectual Property, Latinoamérica en Bayer, Argentina. Osvaldo Pontiggia, Business Development Officer y cofundador de Oncoliq, Argentina. Loreto Bresky, Senior Director de la Organización Mundial de la Propiedad Intelectual, OMPI, Suiza. Moderador, Cristian Bittel, socio de Marval o Farrell, Argentina.
Bueno, un placer estar.
Okay, it's a pleasure to be here with this interesting topic, with such a big impact, and it's so current topic. It's a pleasure to have these panel members. And before getting into this topic, I would like each of you to introduce yourselves and tell us about the activity that your company or your institution does and what is the main activity. Okay, I will start. Good afternoon, everybody. Thank you, Cristian, and I want to thank the organization for inviting me. I am Juan Soria, one of the directors of SF500. We support researchers to build companies. Many they ask to say where to do build flow sourcing to support startups. We don't look for startups, but entrepreneurs or scientists. Based on human talent, the main thing, we help them build startups based on science, based on a company building program. Once they are ready, after some months of work, we invest in them. We're always the first investor, could be an angel investor at the same time. We're the first ones to invest, and we keep working with them. This is what I am doing after the scouting and helping them build the company. We deal with portfolio management. We are an investor. We invest on science around biotechnology, and as Diego Mirage says, one of our advisors. Biotechnology is an IP industry or technology. We have 25 companies that we're supporting. We supported them when they were originated, and when this will be mentioned in a short time. We do the diagnosis, therapeutic, agricultural, business, bioremediation, animals, a whole spectrum of the 25 companies. The very last one, we started 2 weeks ago, 18, we had investments from other Argentinian and Latin American investors, especially US, Europe, and Asia as well. Short presentation of what we are doing. Loreto will tell us about OMPI, about WIPO. There are things, well, I work in the World Organization of WIPO. The main objective is to promote the use of IP and to promote balanced, efficient, and balanced systems as part of the different jurisdictions to work with, to protect the human creation through IP rights, and also guarantee that IP is an efficient or efficient engine to have a social, economic, and cultural development by using IP. This is the goal of WIPO. I'm sure that all of you know what WIPO is, but the goal is, but they don't know about the structure. There's a general director, but there are different sectors. There's a sector led by Juan. She's in charge of the division of brands and designs. She's responsible for brands, designs, geographical indications, Protocol of Madrid, the Hay, and also the Chinese office. Other sectors are copyright, responsible for the legal division of copyright, the corporation in the field of copyright, copyright management, and also the awards. In the region, there's a regional sector that generates the work with the different sectors and different divisions as Africa, Arab countries, Asia Pacific, Latin America, and the Caribbean. And the intention is to get the cooperation with the different jurisdictions. There's a division that you may know because the German framework has participated in ASIPI several times, and they're responsible for the sector of innovation and ecosystems of PI. Under their umbrella, we have the chief economy of WIPO, the umbrella, and data analysis that is providing more and more data to understand the IP ecosystem, technological areas of biotechnology. We get a lot of information from there. Tomorrow we'll have a workshop by our colleague, Mr. Toscano, and one of the areas I belong to of patents and technology is a sector led by Lisa Jorgensen, and we have PCT with 2 areas, or 3 we could say. On the one hand, we have legal and international affairs. These are divisions that are under my responsibility, and the one that is operations. They will absorb the questions that may arise, specific application. And also under this sector led by Lisa Jorgensen, we have translations of PCTs as part of the original official languages and generations of the different languages of WIPO. I'm saying this because sometimes WIPO is perceived just as a space for treaties and services related to that. But this goes beyond. We work directly with the offices and member states as UN offices, and we see the member states. So this is a very global look that I wanted to give you so that you have an understanding, not only the specific case of patents, it's permanent cooperation that we have to comply with our mandate. Thank you. Excellent. And to continue in this sword, Gonzalo, can you tell us about your position, the company? Good afternoon, and thank you. I want to thank ASIPI and the Academic Commission for inviting me. Cristian, thank you very much for the work behind moderation and the previous meetings that we have had. The group, Bayer Group, has been in the Latin American region for over 120 years. It's made up by 3 business units mainly. One is pharmaceutical business unit, another one is what is known as consumer health. That means providing those products that do not require medical prescription for their acquisition, to buy them. This means free access over the counter. And the crop science, that's the 3rd division, basically made up by genomics, vegetal genomics, biotechnology, crop protection, biologicals, and digital farming solutions related to AI and digital things for better productivity as to the use of these products. I would say that they comprise solutions that will help us get better yields with lower costs, and taking into account many things related to sustainability for regenerative cultures. Latin American region is very important for Bayer Group. And depending on each of the different countries, from Mexico all the way to Argentina, the ones that are under my responsibility, I would say that depending on each country, we could have different situations from the economic point of view, and this has to do with the IP game as a research and development company. Well, everything related to higher productivity regarding the different business units. So basically, that is a summary of what the group does in our region. Okay, Osvaldo, I would like to listen specifically to you. Tell us, being a startup, usually in those cases, we have the case of, we're talking about case of companies that are originated based on one first invention, and then others will come. So please tell us what Oncoliq is doing, or what you do in Oncoliq. Thank you. I want to thank the organization. I want to thank Manuel for the invitation. I am Osvaldo Pontiggia. I'm Business Development Officer for Oncoliq. As was said before, is a biotechnological-based startup that is based on CONUCET, the scientific agency from a research lab. We measure some molecules, small molecules in the blood, and we can measure this based by means of PCR and see if there's cancer or not in a patient. This development implies years of research that, well, the conclusion was in 2020 by Maria Simean and others. They decided to make up a startup, having the foundation as a base, all the previous development that had been generated in the scientific field. Today, we are closing the stage of investment that of the seed phase. We collected $4 million. All this is leveraged by means of all the industry on the things that we were able to collect, a process related to learning. And today we have investors. SF500, our first local investor, they gave us the seed stage. But then we started having international players, and we constituted the company in the US. This is what gave us a more global impact. And along that process, it is essential to have very clear in mind what is the pathway that the company will follow. Principally, it has a high risk, many expenses, expensive technologies, slow processes. We need to give certainty to the investors who will put money into a project where they don't know exactly what the results will be. So in that framework, we first aimed at having a good strategy to protect our inversions. Then we have other instances, such as brand protection, contracts, etc., that will give us different tools to sit down at the global tables and have something tangible with which we can negotiate and come to agreements. In the future, this will keep scaling up. This is just starting. We have our first product that will come up next year to the market, if all the regulatory procedures allow so. This will be the first testing plan for breast cancer detection. There's a development for lung cancer, and we are going forward as to ovaries and pancreas. Thank you. Excellent. Having listened to the activities that our panel members have, the panelists have, we have an interesting representation. We can see we have a startup that, well, you will tell us in detail the use of industrial property, a company that has been in the region for the last 120 years, much older even, that also uses industrial IP. A company that funds projects, they also use IP, and WIPO, that is up there managing the tools. So the second question I have for them is, I would like to listen to you. Tell us, please, how you use IP. What is it used for specifically as to the development of this new business? I don't know if it would be good to, maybe Osvaldo can start? Okay, I will start.
La startup
Okay, I'll go first. The startup cannot move forward without intellectual property or industrial property. That's the core of what you will sell in your venture capital project. What you sell basically is knowledge, an idea that is already proving that it may work, and that's the only certainty you have. So at the time of forecasting, that's the engine that drives a startup. As I've already said, there are some people who invest at an early stage with a high risk, and the only warranty is that intangible asset that is what will eventually provide that return on investment. Technology moves forward very quickly. What is an advantage today may not be an advantage tomorrow. So as you get more certainty on what you're generating, you have to protect your asset so as to move forward in the investment process, so as to have more funds and capital and to cover a larger territory. So with Oncoliq, this has always been our priority. First, with a group of lawyers, we defined how we would protect that intangible asset, and then we set up our lab. Once we had already defined that would be the legal pathway we would follow, and that's when we started to develop Oncoliq. And I have a question about what you've just said. Very frequently, all of us here see that when the inventor comes to see us because they want advice to protect their assets, some things have already happened. The inventor published some information, or they made a disclosure that shouldn't have been made. And very frequently what happens, and it's only natural, that a researcher thinks of the technical problems they have to work out rather than legal issues, protection strategy. We'll discuss this with Juan later on. And what usually happens is that once they come to see us, it's already late, and very frequently it cannot be solved. What called my attention is that you said that you first focused on the legal aspects, contracts, how you were going to protect your technology, and only then did you focus on the technical solution. Marina is a scientist, but she has a good vision of the potential business. This is different from the typical scientific culture, and she has always been very careful, and she's always been very well advised about the next steps. This is why we also have a different legal structure. We are a company in Argentina, but legally the company is based in the US. Today we provide the research core to the American affiliate, and we protect our invention from the American affiliate. This is a result of the support of our legal experts who have always supported us to protect that invention. We know that it's a disruptive technology. MicroRNA is not yet the standard platform. We're one step ahead of the industry, so we knew we had to really take care of this invention. We also need a solid patent, and this is what we did. We're quite confident. It's a rapidly evolving field. There are many technologies today that are competing with us to detect cancer at an early stage. So it's a race, and in that race you have to use all the potential tools to be the first one. It's really not the usual thing. It's quite a good thing because you start the business from a totally different place. Gonzalo, I'd like to hear about the experience of a big company with a large patent portfolio in most jurisdictions. How do you use industrial property from Bayer's perspective? Well, with Bayer, from the beginning, when a development is created, it goes through all the different stages of intellectual property, trademarks, patents, rights, and that what cannot be registered, which is technical knowledge, know-how, or business confidential information. So according to the development, we go through these different layers of intellectual and industrial property rights protection. I was listening to Osvaldo, and I agree that the issue is how to make the most to exploit what you're developing. For example, in the case of biotechnology, there is a lot of time behind a product that reaches the market. On average, a research and development process for a biotechnological event that becomes part of a seed and is eventually marketed is about 16 years until the product reaches the market. This implies that in several research stages, in the early stages, you're trying to get to the result, but you fail in those R&D processes. You have to start all over again. In terms of costs, it takes about $110 million to take the product to the market. And there is also a very important component to be taken into account, that is the time the regulatory process takes, not only because of regulations, but also because of intellectual property protection. And because of some deficiencies and some idiosyncrasies in a region, I would say that takes 50% of development time. So it's quite the time you have to exercise that exclusivity right is quite short. For us as a company, there are three aspects which are key when launching a product. Number one, intellectual property. I would say that's the first founding block when we think of launching a product in a country. Number two, a regulatory system that is predictable and that works. And number three, a system to defend and protect IP rights. This generates a contractual mechanism where terms and conditions are set to protect that intellectual property. Once those three conditions are met, you have the green light to launch the product in a given country. Imagine that in a region, depending on the countries, we face different challenges. And this is what makes product launching not so consistent in all countries at the same time. It varies depending on the challenges or obstacles we face to have the full protection of our developments. So We have heard about the use of IP from a big multinational company, from a small startup company. Now, what happens from the point of view of a company that makes investments in a company that's only now starting, and that's based on innovation, that's based on an idea, an invention? What's the weight of IP there? In our case specifically, we are a venture capital investor in science, and IP has always been critical for us. And within IP patents, specifically for 2 or 3 reasons. Number one, we only invest as venture capitalists in a specific type of company, which is companies with a very high growth potential. And we invest at a stage that's so early that there is no return. Sometimes we only have a rough idea of what the business is going to look like. But the first thing we make sure is that there is a huge potential market. For example, detecting cancer with a drop of blood and with a PCR system that any town may have. And from the cloud, you can provide and offer early detection. That would change early cancer detection business. That's the type of projects we like. Now, how can I, as an investor, I want to invest, but when Adriana de Servi makes an invention, I don't want Juan Soria and say, hey, it's a relative modification of this set of RNAs. And okay, that's great. The corporation has created values. Patients, physicians, they all get value, but the startups and the investors who believed in that company do not get any value. And this is why we need to create a mold that is a defense system around the castle in the Middle Ages, so that those who are creating value will keep the value. That is the startups and the investors, so that we can keep investing in other companies, Oncoliq or Green Cup Tech, which is also developing a process to optimize photosynthesis in leaves. That is, the way we have to ensure this business in the long term and to support more scientists is through the IP. The IP is the tool we have to ensure that we will get our value back. In venture capital, the commercial success rate is quite low. Some reports say that half of startups do not give us our investment back. And 1 out of 100 will give you your return back. This is why our startups are 25 and the patent portfolio exceeds 50, because that's the way we have to make this business possible. The venture capital was invented without requesting any mortgage warranty, because we invest to become partners of the project with state-of-the-art science. Third child, Intel founders first founded Perchel Semiconductors and Technology, the first company in biotechnology in the world, Genentech. This is the one that achieved the highest value rate in the world, was based on a great scientific breakthrough, which was a capacity to produce microproteins in microorganisms, insulin in this case, and a set of patents and venture capital. The growth of venture capital industry in the state is associated to the Dole-Act Act that grants the patents to the universities and access of funds to venture capital. So it's a critical element in our industry. And at WIPO, how do you cooperate with this innovation process that may be protected. As Juan said, and Osvaldo as well, it is key for that business to be feasible and for that same company to be able to keep innovating.
There's a vision by some startups here whose founder had a vision to incorporate IP, as Gonzalo said. This is the essential pillar as part of the first point of the business to go forward and launch products on IP and as part of capital, as part of the business. This is a part from WIPO. We have, as part of this ecosystem with different players, we participate together with, in collaboration with the offices. Offices are those places where the first protections will take place. The application submission regarding patents, to have the internet knowledge to analyze those things. From the point of view of startups, in this case, it is nice to hear that from the beginning, at the very, very early stages, they consider IP. But this is not the case. Not always that is the case. So we are really worried about generating awareness so that IP becomes a tool that will allow them to go forward with venture capital, with funding, to be able to go forward as to the development of their innovation with the right protection. And it has to be at early stages. Also, not only is it enough to look for the right protection, but also to write a patent. Last week, there was a workshop organized by ASIPI and WIPO with patent wording. I can have the protection, but if the patent is not well worded, the fund will not be provided. So we have to look at it from the holistic point of view to contribute. That's why we are worried about generating awareness, human capital, and knowledge that can absorb this. We work a lot with the offices and technological transfer offices, those places where the knowledge is being generated. I see different colleagues here who started with the professional exercise in the 90s, and they have evolved a lot with the IP, with the perspective of universities, by the thrust of generation of public policies of the different countries to incorporate more and more IP. Universities have a system of internal ranking. We publish, and on the scientist side, this is what we feel proud of. And we don't see IP as an ally. They feel this is not my field. It's kind of offensive for some of them. So we work together with agencies of the different countries, and we keep working, and a lot of ground has been covered so far. But when we are talking about Oncoliq and others that you mentioned as venture capital or buyer, they protect not only a market to do with that knowledge. The goal is to have a global impact. This global impact will not only be reduced to the Argentine market, but regional, or those markets where it is called for innovation to deliver the solutions that are being expected. In the case of having a solution with a drop of blood that can prevent cancer or can have a cancer diagnosis, I am sure that in any part of the world this could be applied. On associated costs, we can look for markets where development can happen, or alliances with other labs, that can work with innovation, other pharmaceutical companies. I'm the principal director of TCT, cooperation treatment in the field of patents. In order to use an international protection of that innovation, TCT is a space that will allow to gain time for assessments of raising capital, to see that the innovation from the time it is submitted, see what is happening with other markets, to look for those markets. Eventually, I will be able to place that innovation. And sometimes this happens. I raised the application and of a patent, and I realized that it's not so innovative. There's a competitor that has shown up, and it's even cheaper. So I will never be able to trade or have an impact with my innovation properly. The time lapse implied in PCT will allow those necessary adjustments will be made to get into the national phases properly. That is part of what we do. And tomorrow a workshop will be held, my colleague Rando Hernandez on PCT, to work on a simple platform to request PCT. This is very quick, but there are many activities that we deal with, that we do as to cooperation, working with digital platforms that will allow us to do some search as part of the scope, an initial search. Innovators can work on the classification of patents, something quite technical, and we give training on that as well to see if that innovation in an initial search, to see if this has certain viability or not globally, to see what is the patentability requirements. This has to do with infrastructure. And I insist, PCP, for what you are mentioning, this is a space as administrators of the treaty, something that we promote to internationalize that innovation with their easy and safe topics. Can I cascade this to the ground? In the case of the fund, first we look for the scientists. When we look for the scientists, IP chapter is a chapter where we invest a lot of time in analyzing if this can give origin to a portfolio of interesting patents. Evidently, 99% of when we ask them if they have had the patent, the answer is no, because of the Argentine system. Not only the current funding, but this has been the case for the last years, many years. CONICET is the main organization that deals with patents in Argentina. After the company building process, since most of them do not have a patent, we help them start building their stack of IP portfolio, helping them build a landscape of a patent with specialists, where researchers start learning the basic tools that usually in the scientific system they are not there, using patents, Google Patents, Lens. But they should have all the information. Usually they do the scientific literature background, but they don't do the one on patent. And they start listening, analyzing the details, seeing where am I going with this patent. Many times they need to have a patent at a certain milestone, otherwise there's no investment. And regarding what Loreto mentioned about the markets, patents are essential in the markets in Argentina. In Argentina, we say they move the needle. They have to be relevant enough to pay the investment. So coming from Argentina, a country of 45 million inhabitants, small markets, venture capital from the very beginning, it's a global industry. And the most important markets in general are not in South America. In the agricultural field, there's an important market, but human health, Europe, US, China, Japan, Korea, Australia, they're important markets. Brazil, of course, it's also important. But always it's IP from a global perspective. Somehow related to this comment, the question is specifically for Osvaldo. How do you deal with science? How do you do science? How do you innovate? And based on that, generate a company from a jurisdiction such as Argentina or any of the jurisdictions in our region that have to do, going back to Loreto's comment, we have Argentina, Paraguay, Bolivia, Venezuela. We are not PCT yet. And what is the impact of that in a company that is not defining a protection strategy, so that then, based on that protection, to build a company? What kind of problems have you found? I will cover different topics. One is a cultural thing. As Juan said, it is changing, but initially these are two topics that technically compete. Scientists don't decide to be entrepreneurs as their own professional path. They can apply their knowledge to investment, and the scientific system is directly positioned with the number of publications that you generate as a scientist. Grants will be associated to the number of publications that you will raise as scientists, or to be left outside the career or the race as to knowledge is concerned. At some point in time, you need to balance and see what is more convenient, not to publicize, not running the risk of having this study conclude ending up as a patent or not. And that is a big leap. In our case, we were quite clear from the very beginning that this was a dimension that could be patented. So it was not published. But when you have a discussion, they ask for evidence. What you are generating is, you have to get into that discussion. We're protecting the patent. We cannot publish. I don't have any certification, peer certification that will certify what I'm saying. So the only protection that we have is the patent documents that will validate your project. That dynamic is the one that will make the scientists to be really motivated initially to the publication. And usually this reduces potential capacity after the patent has been issued. As to Oncoliq is concerned, as I said, we are an Argentine startup. We have always considered ourselves as having global impact. That's why we have always had this holistic view. The region, and I believe there we need to do catch up as to PCT. If we want the biotechnological sector potentially in the field of health, I don't know about agriculture, we want to strengthen this system. PCT is key. We have to go forward at regional level in that. And in fact, this was the first strategy. We joined PCT to have more time. We get 30 or 31 months to say if the strategy is okay. As we evolve or we have good reception and we receive investment of the funds, we decide in which market we can get into, where we will apply. And for us, this is a warranty. If we had to put all the economic effort in protecting our IP, going to the national phase, it would be inefficient because of costs, and second, because you don't know if we will be able to get in those markets. So we're even losing that capital that we're getting. And the startup doesn't have any additional or extra funds. All the time you have, your life is at risk. We are in the valley of death, as they call it. You have to see how you allocate the resources that you're getting. You have to invest strongly as to the financial development of your technology, and also having this strategy parallel to that. What happens, in short, is the original patent will not be the very last one that will reach the market. We have to see this, you integrate this into the sequence, and maybe after 3 or 4 years, you can iterate and have a technology that will be ready to get out to the market and that it's valid in the clinic, because from the lab to the clinic, there's a very big qualitative leap. So PCT, in my opinion, is key, and it has been key for Oncoliq development. We are at a national phase right now. We're protecting the markets that we believe are a priority. As I said, US, as part of health, this represents 50% of the global health market. If we pick Europe and Japan, you get 80%. So that's where we have to aim at. That's where we have the strong market. Latin America will feel a big booster because the big market, that first world, you have regulatory barriers that are quite strict. So a potential strategy could be to get first into the Latin American market, and then with more experience jump to other markets. And that's where IP will have a very important role. See where we will go in Latin America, where society will benefit of all this process. And the goal from the startup is to have a value added to society. That's why, in my opinion, they go hand in hand, value added, society, and IP. Okay, and in the case of Bayer, what kind of problems do you face? Because in the case of the countries which are not PCT yet, the fact that we cannot access PCT is a big barrier for innovators who have limited resources, who need time to get those resources. PCT will allow you to extend some decisions, postpone some decisions. In the case of a company like Bayer, I understand that quite likely it's a complication along the process because there are certain countries which are exceptional, where you have to go forward in a different way, different from the rest of the world. But in short, this is a company with a pipeline of different dimensions, see what dimensions will be protected. There's some timing and funding issue. So it is not a drawback as could be the case in a startup or a smaller company. Now, anyway, you protect your inventions in the whole region. So I'm interested in listening to your feelings, your impressions. What are the kind of problems that you find when you transact applications in Latin America?
As I've said before, Latin America is a relevant market for Bayer. And clearly, you have to navigate the current situation. When you take a look at PCT map, it's quite striking to see the gray countries and the blue countries. Blue countries are members. Gray countries are countries in the southern hemisphere, Argentina, Paraguay, Bolivia, and then in the north, we have Latin America, well, Venezuela. In the patent filing department, what motivates us is to rush during these 12 months until we submit the first application, and we rush to those countries that are in gray today, and we start with all the corresponding filings to avoid later lack of protection. These countries are still important. Because ultimately, what you look for is to exploit development to get a return on your investment. There is a reason why you want to reach your goal, whether in health sciences, where the focus is on patients. In agriculture, it's productivity. But in short, what you aim at as a company is having clear rules, to have consistent criteria. As countries start ratifying different international treaties, the situation becomes more homogeneous. I mean, international patent standards, the process becomes more efficient. Why do all offices have to do background checks when this has already been done before? Today, this takes over 50% of the life of that exclusivity right you have. So from the point of view of a global company, where even though we have a patent strategy in almost all relevant markets all over the world. Despite the difficulties described by Osvaldo, what I see is that having a PCTA would simplify the filing process for us. And it is very important to have predictable rules at the time of investing in and launching a product. And Juan, in your case, what are the problems you see in the portfolio of companies you have supported and that you have helped create? The problem we see is time. Time is the only resource we will never get back, and it is critical for startups. Gonzalo, apologies because I will use your company as an example, or YPF. A corporation is a flow company. They get income and income. A startup is a stock company. You have an investor who invested $200,000, and every day you see how that money goes down. And the only tool you have is your capacity to do things faster. Anything that makes times longer or that increases uncertainty goes against the life of a startup, which is already quite difficult. As I've already said, the success rate of startups is quite low. The fact that Argentina is not a member of the PCT generates a major difficulty in the scientific system because sometimes there's no money, so we protect the product in Argentina only. But as an American investor once told me, that's stupid because Argentina is not relevant as a market. And the same thing with startups. They require lots of energy and time to solve these issues. So we see this in all startups we work with, and we see that in neighboring countries, Chile and Uruguay. When they want people to go and work from there, one of the advantages they mention is that they are part of the PCT. And what generates lots of frustration is the level of simplicity or the lack of clear rules when that intellectual property was developed within the framework of a scientific organization. We have startups that have patents that are owned by the university boards. We just want to have the monopoly of the marketing of that product, but the fact that every negotiation is different when actually they should all be about the same. Some years ago, I was working at CONICET, and with the support of the World Bank and the ministry, we were able to bring Jimena Ares, licensing manager for biotechnology at Stanford. And I was always worried about how to make things better. And she said, do not worry so much about conditions. Just prepare a template. Innovation is a game of many things, and you do not have a crystal ball. So we do have to ensure that it is simple and that you will not have to go through negotiations for every case. Those two things are key for us. Ensuring during a reasonable time, such as time given by PCT, and finding a common language or a common template so that we will not have a new discussion every time we go to the CONICET board or to universities. This has been successful in other countries. In the UK and in the US, they have the 10U and use it regulation that are used by universities, IP people. Altogether, they have developed a base template, and this has improved the effort of universities a lot, but if every case is a new case and it takes a lot of time and resources, when actually we have not made any money, we have not won any game. A VP from CONICET once told me, I sometimes feel we are fighting about the oil when we have not even planted the seed, and that's the case. And you said that one of the critical elements is time, and time is affected not only by the time taken by the process, but also by the time it takes for the different offices to make a decision. And in our region, not all countries, but most countries in our region have significant delays. I guess you have also seen this. And same happens with patent criteria. Some inventions that may be patented in some jurisdictions cannot be patented in others. Sometimes there are reasonable reasons and others there are not. And this has a significant impact on business and on the products that reach consumers. Gonzalo, what has been your experience in this respect? Well, it depends on every country. As you've just said, there is no consistency, even though all countries in the region are members of the treaty that sets the minimum protection standards. Not all countries have dealt with those standards in the same way. Our country is one example, since we have the most restrictive criteria in terms of chemical pharmaceutical tests and biotechnology as well. It calls my attention when you see these inventions with patents submitted in all countries in the region. You can see the progress in the filing of these applications, move forward, all the steps take place at the right time. But in our country, things take longer because of decisions made internally in the office or even because of state policy. This clearly has an impact. It has a huge impact because this is not a test about what is going to be patented, but we're talking about things that go beyond the act or the treaty. And clearly, this is damaging in terms of invention. Some countries have more restrictive criteria, and it may take us 10 years to examine a patent application. And if, besides the rejection, we also have to go to the court, then it takes your whole life to apply for that patent. So all these factors have an impact on our company. Is it worth to keep investing in a country where I am facing this situation? In our case and in some other cases, same thing has happened. Sometimes overnight, the rules of the game change. At the time of investing, you think of a longer term. In our case, specifically in 2021, we had to rethink what we were going to do with the biotechnology business for soybean. There were some draft projects in Congress that might have restricted the scope of some patents, criteria for the application of patents, of inventions in biotechnology, plus other issues. Juan, even though the financial aspects have an impact on all players. So when you turn around and you see Germany, to see the numbers having an impact on investment and what your return is, and when you do not see that there is a business there, then you have to make a decision. And the decision was to put an end to a business, to put an end to the license agreement we had signed. It was quite painful because in a country such as ours, where agriculture has a huge potential, and it is a source of money to our country, and seeing that countries such as Paraguay, Uruguay, even Chile, Brazil, are really having a totally different dynamics, where the launching of the product pipeline is being considered for those countries because we do not face the same difficulties. This is why we had to revisit our investment plans. These are concrete cases. These are not hypotheses of what may happen, but clearly, in the light of certain factors, this is what you as a company eventually decide. Will I invest or not in new products? And IP is a #1 factor. Without IP and without a predictable protection system, then that's not the right place to keep launching new products. So we may conclude that industrial property that protects intangible goods is quite tangible because lots of developments, innovations, businesses are based on this. Without IP, there's no investment for new developments, and so on. This is why it is so important to have a strong IP system. Loreto, well, PCT was a star during this discussion. Those of us who do not have it, not only Argentina, but many other countries in the region would like to have it. But that's a discussion that's happening today in the media in Argentina. So what can you tell us about the implementation and the progress of PCT in the region?
Quite recently, as part of the region, in Uruguay has joined us. In January, Uruguay will have been with us for a year, so we have to see what happens after 18 months have gone by, which will be a key period for the region. We have worked a lot with Uruguay by WIPO to implement PCT correctly. At present, and you have mentioned this, there was a joint statement by Argentina, US, a draft agreement that they have launched, they published, and this referred to harmonization of international systems, different kind of commitments that have generated different articles that we read in the main Argentine newspapers that they talk about PCT. Everybody's talking about that here. So if finally that happens, if that was part of that agreement and then they deal with legislative terms, it has half approval. Argentina was one of the Argentines that was promoters and strong negotiators as part of PCT. And then they signed the agreement. So the ratification is only missing. I was told an anecdote. I can't remember the name of the person, Pedro something. He has been the Argentine negotiator. He is the uncle of Carlos Gallo, so that you can see the connection. So it's quite curious to see that a country of G20, as is the case of Argentina, does not have PCT. This is an aspiration that we have received by the users of other countries, big users of the IP systems and PCT as well, for the reasons that were given here, that Argentina is a pain. It's a pain, the fact for them as users, the fact that Argentina does not have PCT. And we will work hand in hand with the office and the bodies, the relevant bodies, to create the skills, the guidelines, and to train agents, because they have not been involved in the system. This is something that has been there from the very beginning, but this has not happened in Argentina. Once this happens, we want it to happen properly, and we want it to be successful. And for that, we will be quite close to the authorities so that this can be properly implemented with guidelines, training, workflow in the office, at the office. So the same as what was done in the companies that have joined, the countries that have joined, PCT can finish the map that Gonzalo mentioned with this gray area. Argentina is big, so it's quite present, this big stain as part of a global map of 154 countries that are part of PCT. If this happens, as part of our commitment and mandate, the idea is to work together with the country, with Argentina, so that it can be properly implemented. The same with other countries in the region that can go forward with this. Thank you very much, all four. We finish with a message of optimism. Thank you all. I want to thank you all four. I think you properly digested all the things that are happening with the inventor, who has to protect inventions, who funds this, and together they generate, or you generate, business, resources, companies that permanently innovate, and the support of WIPO behind all of them. So with this, I want to thank you for your participation.